Okay, yes, counsel for the second, for the first defendant. Is it Dio Akin Doroli?
Mohammed Adam, my lord.
Okay, Mohammed Adam for the first.
Popularis Bank.
Okay.
Yes, my lord.
Yes, counsel for the CBN. Yes, any person for the CBN, representing the CBN. It was the London SAN, LA Nylanda.
Nylanda.
Yes. Yes, Nylanda, yes.
My lord, if I may be of assistance, my lord, I'm not sure whether he has not been taken out of, whether the suit against them has not been struck out, or perhaps I'm mistaking them for the other ones.
No, this is the case that London SAN is involved in. That is Babatunde.
Oh, okay.
Babatunde.
Agbotafara.
348, 2019.
Oh, okay. Well, I don't think anybody's representing them at this time.
Okay, let's get to the counsel for the third. That is that ACPAN?
NDIC.
Yes.
NDIC.
May I please, my lord?
Yes.
My lord, A. Afan.
Okay, ACPAN, yes.
Yes. My friend Olufunsho Adebowale is also with me for NDIC.
Olufunsho
Adebowale.
Adebowale.
Yes, my lord.
For the third.
For third defendant applicant, my lord.
Okay. Yes, Mr. Adebayo.
Mr. Adebayo, sir. Olashupo Adebayo, sir. My appearance is for the fourth defendant, sir. My lord, my client is represented.
Okay, it's in court.
Yes, sir.
Okay. The Mr. Adebayo, AMCON is represented by who?
She's here. If she can unmute and mention her name for the record. Mayokun, if you are here, please state your name for the record.
Mayokashai for AMCON.
Who?
Mayokun Ashai for AMCON.
MayoKun.
KUN.
And Ashai. ASHAYE.
The other names were Ikeje Gabriel and Abishola Owoju.
Abisola Owoju is my colleague. She's my colleague.
Okay, so you are
Mayokun Ashai for AMCON.
Bayo?
Mayokun
Okay.
Ashai.
Mayo, MAYOKUN. Yes. The other name?
Ashai.
Okay.
ASHAYE.
Okay, your designation?
Legal officer.
Okay. So this is my ruling with regards to the second defendant's application. So this ruling is predicated. This ruling is predicated on a motion on notice dated on file on the 17th of February 2020 by the second defendant applicant praying for the following orders. Number one, an order of this honorable court striking out the name of the second defendant applicant from this suit on the ground that the claimant's rejection process disclosed no reasonable course of action whatsoever against the second applicant. And the applicant is therefore not a necessary party to the suit. Number two, a consequential order dismissing in its entirety the vexatious and frivolous claim of the claimant respondent against the second defendant applicant as endorsed on his originating process in pursuance of the foregoing. The grounds upon which the application is brought are contained on the face of the motion paper. The application is supported by a 7-paragraph affidavit sworn to by one Godwin Willie, litigation officer and the law firm of counsel to the second defendant. 3 exhibits were attached to the affidavit. A written address was also filed by counsel to accompany the application. It was the alarmment of the second defendant that the claimant was a senior management staff of the first defendant that is licensed by the second defendant to carry on banking business. By the second defendant, body empowered by law to regulate banking business. That the claimant joined the second defendant to this suit for not just cause, as the pleadings do not disclose facts to entitle the claimant to the reliefs sought. It was also averred that the second defendant was never at any material time the employer of the claimant, hence the suit disclosing no reasonable cause of action against second defendant. That contrary to the allegation of the claimant, the second defendant has no recourse that it intervened in the claimant's dispute with the first defendant. Second defendant further narrated that the first defendant was incorporated in 2018 to assume the assets and liabilities of the defunct Sky Bank by virtue of the purchase and assumption agreement between the third defendant and the first defendant. But the second defendant is not privy to the agreement and did not assume staff liabilities of the defunct Sky Bank. The said purchase and assumption agreement was attached as Exhibit 3. Lana Senior Counsel to the second defendant in his written address submitted one issue for determination to it. And I quote, whether a cursory look at the averment contained in the claimant's statement of fact and documents pleaded therein are listed discloses reasonable course of action against the second defendant applicant. Lana Senior Counsel for the second defendant referred to the case of Rimco Construction Company and VP Industry Limited and Otubu and Omotayo for the definition of the reasonable course of action, and also submitted that the court must limit itself to the claimant's pleadings and not the statement of defense in discovering whether a course of action is disclosed. And Senior Counsel further submitted that the instance suit discloses no reasonable course of action against the second defendant and therefore deserves the striking off of its name from this suit. Just submitted that the claimant's allegation against the first defendant does not in any way concern the second defendant applicant, as no credible fact has been alleged capable of being proved as a cause of action against the second defendant. It was argued that the claimant failed to show through the set of facts pleaded how the second defendant caused him any legal harm, especially when it considered that it has no interest or obligations in the claimant's employment with the first defendant. The Learned Counsel expressed the view that it is tried that once a court of law is vested with jurisdiction to entertain a suit, it has the powers to take all necessary steps to ensure that justice is done in the case. The rules of this honorable court have empowered the court to strike out the name of any party in deserving cases, like the ilk of the instant application. Citing Order 13, Rule 14.2 of the rules of this honorable court. It is a submission of counsel that the second defendant cannot in any circumstance be allowed to continue as a party when its presence is not necessary for the effectual determination of the relief sought by the claimant, having failed to establish any nexus between the first and second defendants. The second defendant is by no means related with the employment of the claimant in the first defendant. Neither did it assume obligation to pay its redundancy stroke severance package upon disengagement of his services by the first defendant. The counsel contended based on the foregoing that no order can be made pursuant to this suit which will ever affect the second defendant's interest. No order resulting from this suit will even be targeted at the second defendant either. In other words, the second defendant's absence from proceedings will not by any means jeopardize the effectual and complete termination of this suit. Counsel finally urged the court to resolve this issue by striking out the name of the second defendant from this suit, as no reasonable course of action has been established against the second defendant. The claimant, in opposition to the application, filed a 12-paragraph counter affidavit on the 10th of March 2022. A written address was also filed to accompany the counter affidavit. Claimant stated in his affidavit that the second defendant, in conjunction with the third and fourth defendant, acted in acquisition of the Main Street Bank, which translated to Sky Bank, and now Polaris Bank, by reason of which the defendants are bound to settle the entitlement of the claimant. That upon the institution of this suit, the first defendant stated in his statement of defense that it was the second defendant that incorporated the first defendant, by reason of which the second defendant is the brain behind all the activities of the first defendant, respect of the claimant. Another counsel for the claimant is written address formulated 3 issues for determination as follows. Number 1, whether this honorable court can assume jurisdiction over this matter as constituted. Number 2, whether or not the second defendant is a proper and necessary party. Number 3, whether this suit is competent. Counsel posited that the determination of the court's jurisdiction or competence, certain factors should be considered. It has been held in the case of EFPC and NDIC. It was also submitted that jurisdiction of court is determined by the claimant's claim as endorsed in the writ of summons and statement of claim. It was further submitted that the issue relating to disclosure of reasonable course of action is an issue of law which is precluded from being supported with an affidavit and does not require any evidence, whether oral or documentary, and no affidavit evidence, save the element contained in the statement of claim. And by reason of the above, this court, in considering the issue of reasonable course of action, is precluded from considering any evidence by of affidavit evidence in support of the instant application. Referring to Order 30, Rule 18 of the rules of this court, Counsel argued on issue 2 that the second defendant is not only a proper but necessary party to this suit, without which the controversy between the parties would not be effectively and effectually resolved, citing the case of Green and Green, where it was held that a proper party are those who, though not interested in the claimant's claim, but are made parties for some good reasons. Citing also the case of Ajibola and PSTSC Ekiti State. Counsel further argued that the reason why the second defendant was joined as a party is to enable the court to effectually and effectively adjudicate upon and settle all the questions involved in this case. It's also submitted that all parties who may be affected by the result of litigation are made parties to such an action. Hence, the second defendant's name cannot be struck out, nor the action dismissed against it. Counsel referred to paragraphs 5 to 11 of the claimant's counter affidavit, most especially as the first defendant disclosed that he, the second defendant, incorporated the first defendant, citing the case of Osun State Government and Crucial Engineering PLC. And order 13 rule 4 of the rules of this court. The second defendant on the 1st of April 2022 filed an 8th paragraph further affidavit, a reply on points of law, and attached one exhibit. Counsel submitted a response to the issues raised in the statement on the claimant's written address that the customary law at the statement of facts in this case does not reveal any reasonable cause of action to entitle the claimant to his claims against the second defendant. Counsel referred to sections 3 and 52 of the Central Bank of Nigeria Act 2007 and the case of Usanga Ayo Brain, an association of senior staff of banks, case of Oredoya OK Trading Company, and Bank of Credit and Commerce International. The revocation of banks' operating license does not mean that it's no longer in existence, except where there is evidence that the bank has been wound up or dissolved as a legal entity. This is my opinion. I have gone through the processes filed by the parties in this case, the issues submitted, and submission of the respective counsel to the contention of the second defendant that the claimant's claim did not disclose any cause of action against the second defendant, and its name should therefore be struck out. Now, it is tried that a cause of action is constituted by the bundle of or aggregate of facts, which the law will recognize as giving the claimant or plaintiff a substantive right to make the claim against the reliefs or remedy being sought. The factual situation on which the claimant relies to support his claim must be recognized by the law as giving rise to a substantive right capable of being claimed or enforced against the defendant. In other words, the factual situation relied upon must constitute the essential ingredients of an enforceable right or claim. See the case of Bello and AG Oyo State. In the case of Akilo and Fawehim, number 2, it was concisely stated that a cause of action is any act on the part of the defendant which gives to the plaintiff his cause of complaint. From the definition of cause of action, the proposition resolved into 2 crucial factors. Thus, the defendant's wrongful act and the consequential damage to the claimant. These two factors must coexist to constitute a cause of action before the court. It does not take account of whether the cause of action will succeed or fail. A cause of action is valid irrespective of the strength or weakness of the claimant's case. See the case of Idigbe and Apollo. It needs to be stated here that the quotation of the second defendant that the claimant has no cause of action against this will be determined by examining the averment made in the claimant's pleadings. It has nothing to do with the nature of the defendant's defense. This court will only confine itself to the averment in the pleadings to assess whether there is a reasonable cause of action or not. I need to examine here the facts averred by the claimant in this is the statement of fact. The relevant facts averred at paragraph 2 of the statement of fact, which reads as follows, and I quote: the first defendant is a public liability company incorporated under the Companies and Allied Matters Act 2004, dealing in banking business, with its registered address at number 3 Akin Adiola Street, Victoria Island, Lagos State. Second defendant is a body empowered by law to issue and revoke banking license to banks and all insured institutions in Nigeria. While the third defendant is the body empowered with rights to appear in court on behalf of an insured institution, such as the first defendant hearing, whether it bears Main Street Bank, Sky Bank, and or Polaris Bank, and it is empowered by law to render financial assistance to an insured institution, such as the first defendant hearing, whether it bears Main Street Bank, Sky Bank, and or Polaris Bank, empowered to close a failed insured institution, such as Main Street Bank, Sky Bank, and or Polaris Bank, empowered to act as liquidator to an insured institution, such as the first defendant hearing, whether acting as Main Street Bank, Sky Bank, and or Polaris Bank. And it is the second defendant and third defendants in consultation with each other that are empowered by law to incorporate a bridging bank, which the first defendant hearing claimed to be by a statement of defense hearing. The fourth defendant hearing is the body that acted in conjunction with the second and third defendant hearing in acquisition of Main Street Bank, which translated into Sky Bank and now Polaris Bank Limited, unquote. The above amendment clearly shows, firstly, that the second defendant is the body empowered by law to issue and revoke banking licenses to banks or insured institutions in Nigeria. And secondly, that it was in connotation with the third defendant that the second defendant incorporated the first defendant as a bridging bank. Following from the above, I'm of the opinion that this mere amendment only does not clearly entitle the claimant to hearing on merit of his case, and I do not agree with the learned counsel for the claimant that there is a valid cause of action against the second defendant. I do not think that a body who is only empowered to issue or revoke licenses and or incorporate a bridging bank must be made a party in a suit for claim of entitlement. In the case of Chevron Nigeria Limited and Lone Star Drilling Nigeria Limited. The fact that a second defendant could issue or revoke license and or incorporate a bridging bank without more does not automatically make it liable for the action or inaction of the first defendant. The claimant should go further to aver and prove that the role played by the second defendant in the instant case entitles him to claim for his terminal and redundancy benefits. In other words, the claimant has not been able to prove that the conduct of the second defendant has done some wrong to him, a wrong which justifies a relief in law. See the case of Rinco Construction Company Limited and VP Industries Limited. While the second defendant is a proper or necessary party, it has long been held that proper parties are those, though not interested in the claimant's claim, are made parties for some good reasons. For example, in an action instituted to rescind a contract, any person who was active or concurring in the matters which gave the plaintiff the right to rescind is a proper party to the action. Meanwhile, necessary parties are those who are not only interested in the subject matter of the proceedings, but also who, in their absence, the proceeding could not be fairly dealt with. In other words, the question to be settled in the action between the existing parties must be a question which cannot be properly settled unless they are parties to the suit instituted by the plaintiff. See the case of Chief Abusi David Green and Dublin Green. Considering the above, therefore, I do not think that the claims of the claimant in this case cannot be settled without the presence of the second defendant. In the light of the above, therefore, I am satisfied that there is no reasonable cause of action against the second defendant, or there is no nexus between the claimant and the second defendant on the face of the pleadings, and it should not so remain a party in this suit, and its name ought to be struck out, and I so order. See the case of Thomas and Olufosoi. Yes, Mr. Ajay.
Lord, we are very grateful for the ruling.
Thank you. Yes, Mr. Ajay.
My Lord, we are very grateful for the ruling.
Thank you. So, what do you do next?
My Lord,
Mr. Ajay, yes, I can hear
My
you.
Lord, now that the name of the
Second defendant.
second defendant is off the matter, so
Yes.
well, we have some. I think there are some pending application in respect of other defendants, so which can be taken, and as soon as all the application is determined one way or the other, we will know the next step to take.
But Mr. Ajay, what's your instructions with regards to the application of the fourth defendant?
What?
Yes,
I'm sorry, my Lord.
that's AMCON.
My Lord, for it to be taken.
No, I mean, what's your instruction from Mr. Abdulsalam? It's like Mr. Abdulsalam was saying that he may constitute the application of the fourth defendant.
Pardon, my Lord.
Your instruction from Mr. Abdulsalam with regards to the application filed by the fourth defendant, whether you are still contesting the application.
Yes, my Lord, the instruction is that the application be taken so that the court can rule on it one way or the other.
Mr. Ajayi, the thing is that, please, should I go and be writing rulings on something that's so, like
as the court pleases.
Mr. Ajayi, the fourth defendant. Mr. Ajayi, can you hear me?
My Lord, I'm with you, my Lord.
And like the fourth defendant, do you actually have anything against AMCON?
My lord,
With regard to the payment
ordinarily,
yeah. We are talking about the payment of entitlement of the claimant. Is that not
yes, my
so?
lord, ordinarily when we filed the action, we didn't join the second to the fourth defendant. It was the defendant's defense that prompted joining them.
No,
It was
but
the first defendant.
yes, but can can you prove your case by the argument made by the by the first defendant in his statement of defense, just by the first defendant saying something against any other person, without you having any concrete fact?
Yes, my lord.
Mr. Ajayi, Mr. Ajayi, Mr. Ajayi,
my lord,
can you hear me?
I am with you, my lord. I can hear you, my lord.
Yes, the only averment
Yes.
you have in
Yes.
your pleadings,
Yes.
the pleading that was not regularized, that pleadings you filed,
Yes.
Mr. Ajayi, that pleadings that the claimant filed was not properly before the court, because you applied to join the CBN, NDIC,
Yes, my lord.
and
Yes, my
AMCO.
lord. Yes,
Then
my
when the
lord.
application was granted, you just went on your own and amended your statement of fact without any leave from the court. And even this averment, there is nothing said in the averment, that is paragraph 2 of your amended statement of fact, against the AMCON. Against the AMCON. It's a simple, that is the averment I've just read in the ruling. What the
Yes, my lord.
What you at least said was the fourth defendant hearing is a body that acted in conjunction with the second and third defendant hearing in acquisition of Main Street Bank, which translated into Sky Bank, and now Polaris Bank Limited. Yes, so based on that, can the court, say that the fourth defendant is, or there is any reasonable cause of action disclosed against the fourth defendant? So that will save time, please. I don't need to go and make.
Yeah, okay, my lord. My lord. I guess I can now understand the int of the courts. If that is the case, maybe we can apply to for the name.
Because Mr. Ajay, the thing is that, as far as the court is concerned, the claimant.
Yes, my lord.
The claimant's amended statement of fact is not properly before the court. What I have as a statement of fact is still the initial one that you file against Polaris Bank.
As the court pleases.
Mr. Salam went and amended without any leave.
As the court pleases.
Yes, he went and amended without any leave. So the challenge is that if the fourth defendant now asks the court to strike out its name from the proceedings,
yes, my lord.
what avenue am I going to use to hello?
I'm with you, my lord.
Mr. Ajayi withdraw against us and take us out of these proceedings. You know we are not supposed to be here. The party you are after is still.
No problem, sir. No problem.
Whatever you decide to do, we are here.
Okay. Yes, hello?
No problem. My lord.
All right.
Mr. Ajayi.
Yes, my lord.
Yeah, what I was trying to say is that, when you join the other defendant, that's from the second to fourth defendant, and your application was granted, you just went ahead to amend the assessment of fact without the leave of the court. So my question to you is that the second defendant's name has been struck out.
Yes,
The court defendant is now asking, the court to strike out his name from the proceedings. So what assessment of fact should I use to determine whether there is reasonable cause of action against the fourth defendant?
My lord, as your lordship earlier said, that in order to save the time of the court and all of us here, my lord, won't be applied that the name of the fourth defendant be struck out.
Okay. Mr. Akpan, any objection? Mr. Akpan.
May I please, my lord. My lord, the application is to strike out the name of the fourth defendant. We don't have a problem with that, sir. So we are not opposing.
Okay, no objection.
We too, we are ready to pray that our name also be struck out.
Mr. Adebayo. Mr. Adebayo.
Well, it's a good development. Thank you very much, my lord. It's a good development. Ordinarily, I would have asked for cost, but in the interest of fairness and fair play, I think it's only proper at this stage to leave that issue to the discretion of my lord. As the court pleases, sir. I cannot oppose the application to have an name taken out.
Okay. So sorry, Mr. Mohammed. Mr. Mohammed.
Yes, my lord.
No objection, ba?
No objection at all.
Okay.
It appears we have to battle with the claimant alone, as the other defendants are leaving us to our fate.
No, there still remains the third NDIC.
Okay, yes. So it's AMCON and CBN that are out.
Yes.
I wouldn't know if Mr. Ajayi is considering, removing our name from the matter as well.
The Polaris Bank?
Yes, my lord.
What should the name of the Polaris Bank be?
That was just on a lighter mood, my lord, not on
You are the main defendant now.
Yes, my lord. Maybe once to save time and the time of the court as well. and that will reduce the number of cases in the court docket as well.
But Mr. Mohammed, are you, is the first defendant still illegal? Or I mean the other banks, that Skybank, is still a legal entity?
Yes, my lord. In fact, there is a, yes, my lord. There is even a judgment of the Court of Appeal that says that Skybank is still a legal personality.
Okay, and the claimant was a staff of Skybank or Main Street Bank? He was a staff of
Yes, my lord. Yes, my lord.
Okay.
Well, we'll deal with all of that.
Okay.
At the hearing.
Do you understand?
So in view of the application of the counsel for the claimant to strike out the name of the fourth defendant, the fourth defendant's name, NDIC, is hereby struck out from this suit.
So, my lord, for
AMCON, the four defendants.
the records of.
Okay, sorry, AMCON.
Fourth, sir. Fourth.
Okay, sorry, not
Fourth.
NDIC. Sorry, AMCON.
So, as I was saying, my lord, for the record to be neat, what would I would respectfully be allowed to do now, my lord, is to withdraw the notice of preliminary objection. To withdraw the notice of preliminary objection, so that it will no longer form part of pending, because it hasn't been argued. So I will just simply withdraw it so that it can be struck out. I think for the record to be very neat.
But did you need to do that, Mr. Adebayo?
Sorry, my lord, I didn't get.
So do you need
do I need to do it? No, it's fine. Well, I just feel that it's a pending. I feel that it's a pending process.
Do you need to withdraw any application?
Well, now that my name has been taken out, I guess the point my lord is making. So it's like it was never filed.
The striking out of the, your client will go with all the proceeds that your client filed.
Will go out the window automatically. As a copy, please. As a copy,
yeah.
As a copy, please.
Yes.
So I'm much obliged, my lord.
Thank you, Mr. Adebayo. Yes, Mr. Yes, coming to Akpan.
Yes, may I please, my lord? My lord, we have a notice of preliminary objection.
Mr. Akpan.
May I please, my lord?
Yes, you don't think that it should be, a necessary party?
Yes, my lord. My lord, the law says, the NDIC Act particularly forbids that we should be here and that we don't want to run afoul of the law, sir.
What does law say?
Lord, the law is that the NDIC, just like the name suggests, can only deal with liabilities from banks arising from deposit claims. It doesn't have the powers to deal with employment claims. It doesn't. That is what the NDIC Act says. So the contention.
Okay.
Yes, and my lord, should I say so, sir? Should I say too, sir, that your learned brothers at your lordship's court have also affirmed position, yes. In the case that was cited, Osame O'Brien and others,
yes, cited by the.
Yes, I actually was part of the team that did that case for NDIC, and that position was reaffirmed. I'm sure my Lord would find good reasons.
Okay, that's the case of Osanga.
Yes, yes, my Lord. So the whole misconception, I think, starts from where the claimant feels that because the NDIC is said to be a statutory liquidator for failed banks, that they have to be responsible for all claims against the bank, but that's not what the NDIC Act contemplates. And your Lordship's court has in many instances reaffirmed that, just like the name implies, everything that the NDIC has to be concerned with is depositors' claims and not employment claims and all of that. I think that's like the particularly narrow issue.
Okay, but in this case, Mr. Akpan.
Yes, my Lord.
There was a purchase assumption agreement.
The purchase assumption agreement was in favor of
which NDIC was a party to. NDIC was a party to the purchase assumption agreement. That is between the NDIC, I think, and Polaris Bank.
Particularly, my Lord, to protect the interest of the depositors' funds that they have the statutory mandate to protect. It was also the same situation in the Osame O'Brien case.
Okay. Even though in the purchase agreement, it was stated as a term that the NDIC is going to, assume in liability of employees.
My Lord, may I please, my Lord, while assuming without conceding that term was expressly spelled out, the position now that I know my Lord would have to take a decision on it, whether that term is correct in law in view of the statutory mandate of NDIC. The NDIC cannot, by agreement, amend the enabling statute that gave all the powers it has. So once the act has said clearly that this is what they can do, they cannot go outside the act. So assuming without considering that parties in error made that decision, that liability cannot be put on NDIC now, because really all the money that the NDIC has to settle all claims against it in favor of banks has to come from depositors. So if NDIC has to use money from depositors, let's say in Access Bank, to settle employment issues of Polaris, that wouldn't be what the law contemplates. So we are saying that what my Lord would have to go with the act.
It's okay, Mr. Ajayi.
Hello.
Mr. Ajayi. Are you ready to take the third defendant's application? Are you ready?
Yes, my Lord. Yes, my Lord.
Okay. Okay, so Mr. Akpan, your application. Mr. Akpan.
May I please, my Lord? My Lord, our application is dated the 24th day of February 2022.
Is this a motion notice or is an notice of preliminary?
A notice of preliminary objection.
Okay.
Dated 24th day of February 2022 and filed on the same date, my Lord.
Is that filed?
24/2/2022.
Yes. Yes. Yes.
Yes, so my Lord, on the face of the motion paper, we highlighted 3 grounds.
Yes.
We had canvassed that the claimant had not issued the mandatory pre-action, the mandatory pre-action notice on the corporation, but in their reply, they had shown that they had done that, so we would waive that ground. So my Lord, we hold here 2 grounds, one being that there is absolutely no cause of action raised against the 4th raised against the third defendant. Indeed, my lord, Lord, in support of the motion on notice, we have a 10-paragraph affidavit. My lord, the affidavit is deposed by Mayor Okun Breathwith.
Yes.
It's also dated and it's also filed the same 24th day of February. And in line with the rules of my law's court, we have a written address dated and filed the same 24th day of February. Lord, we respectfully adopt the written address as an oral argument in support of our application.
Yes.
But my lord, if my lord would allow us, the kernel of the application is just two things.
Did you file any reply?
No, my lord, we did not file any reply.
Okay. Okay.
Yes.
Yes.
My lord, the kernel of our objection is just on two limbs. One, my lord, a review of the entire originating processes. There is absolutely no allegation of fact against the third defendant that led to the filing of this suit. That's the one side of it. And when my lord agrees with us on that fact, the next point would be, why then has this suit been commenced against us? The argument is, the argument by the claimant is that the NDIC is a statutory liquidator of failed banks. But my lord will find in cases that we have cited that even failed banks still have legal personality. And if there are claims arising from wrongs that they committed, they are still potent defendants that should be called to defend those claims against them. Then on the other.
Okay, but how can a claimant enforce his right against, a liquidated bank? Like in this case, the claimant is asking for his entitlement. How can he, supposing Sky Bank is liquidated, so how can the claimant enforce his right against a bank that's liquidated or window or taken over by another bank?
So, my lord, the issue of corporate personality is slightly different from whether they have the capacity to pay the judgment sum, assuming one is arrived at. The technical issue, the legal issue is that that person is still alive and competent to defend the suit brought against him. And even the Court of Appeal has agreed with us that failed banks still have corporate personality. That what actually happens when a banking license is withdrawn is just that the banking license itself is moved away. Probably they still have assets. We cannot say whether they have or not, but then the law says that the corporate personality is still there and they cannot be intermingled with the new entity, assuming without conceding. Then, also the next point is, does NDIC have the statutory powers to deal with the employment claims? The answer is no, because the act is very clear. We have cited the provision of the act, and I am confident that when my lord reviews the written address they filed, that my lord will find enough support to uphold our objection. We are grateful, sir.
Thank you. Yes, Mr. Ajayi.
Lord, in opposition to the application of the third defendant, we file a 13-paragraph counter affidavit deposed to
Yes.
by Abdusalam Ismail Toyin on 8th of March 2022.
Yes.
Attached to the counter affidavit is an exhibit, which is
Yes.
marked Exhibit A. And in compliance with the rules of the court, we file our written address dated 8th of March 2022.
What is that exhibit?
It's Exhibit A, which is a letter dated 15 January 2020.
Okay. Yes.
In compliance with the rules of court, we file our written address dated 8th of March 2022.
Also file our
Written address
written
dated
address.
8th March 2022.
You file when?
8th March 2022.
Okay. Yes.
We adopt same as our argument in support of our counter affidavit, and we urge
Yes.
we urge the Honorable Court to dismiss the application of the third defendant applicant.
Yes.
Very good, my lord.
But Mr. Ajayi,
Yes, my lord.
there was a purchase assumption. It's just purchase and assumption agreement, or what do you call it?
Assumption agreement. Purchase and assumption agreement.
Yes, between the NDIC and the
Polaris Bank, my lord.
Yeah. But it didn't deem it right to even attach that agreement to show the involvement of the NDIC in your case.
My lord, we didn't have access to the document. It was a document from the defendant. It is the defendant that brought the document. We were not aware of it initially.
Okay. But you, okay, having the defendant, especially the second defendant, file that document, you now have access to the document.
Yes, we now have access to the document now.
Okay, did you go through it?
My lord, I've gone through it.
Is there anything in the agreement that shows
NDIC and Polaris?
Yes,
yes, it's very simple that. Yes, my lord. Yes, my lord.
Is there anything in the agreement that shows how liable, that shows how, the role played by the NDIC, irrespective of entity?
My lord, even from the inception, it is clearly stated that the assuming bank,
yes,
agreed to assume certain of the record deposit liability and certain other liability of the failing bank.
Okay.
In consideration of the acquisition of the asset of the failing bank.
But did the counsel for the NDIC attach that document to his counter? Oh, okay, the application.
His application, no, my lord.
And did you refer to that agreement in your counter to his application?
My lord, no.
Then how do you get that document? It was filed by the counsel for the second defendant.
Yes, my lord. Yes, my lord.
Yes, my lord. Then when I come to to rule on this application, this instant application, how can I refer to that document?
My Lord, the law is very clear that
if that document is saying that this is the role played by the NDIC with regards to the claim of the claimant, so when I come to make my ruling on this instant application, how can I refer to that document?
My Lord, the law is very clear that documents that form parts of the record of the courts, that is in the file of the court, can be looked into in consideration of issues by the courts.
But in your counter, you didn't refer to that document.
My Lord, as at the time we filed the counter, I'm sure we are not aware of it. We are not aware of it.
That is why I was asking you whether you are ready or not. And in your claim also, in your assessment of fact also, did you say, this is the role played by the NDIC with regards to the claim of the claimant?
My Lord, what was stated on our statement of fact is as contained in paragraph 2, my Lord.
Of the amended statement of fact?
Yes, my Lord.
The one that was amended without any leave of court?
The application that we brought before the court is to join them based on the ground that are stated there. And my Lord, when they are joined,
Yes.
it's a consequential process that we file to state the ground upon which they are joined.
Okay, so the moment a party is joined, the claimant can go ahead to amend.
When the parties is joined,
yes,
the claimant will file consequential process reflecting the amendment. And the application that was granted, the reason why they were joined is stated, and which is the description given in paragraph 2. Well, if not for all the preliminary objections that have been filed, we are required to bring another application to now amend and bring other facts into the matter.
No, what I'm trying to say is that after joining, you had already filed an amended statement of fact.
Yes, consequential amendment, yes.
But how is it consequential? Why do you call it consequential amendment? How is it consequential amendment?
My Lord, they were joined by the order of court on the ground as stated in paragraph 2 of the statement of facts, that this is the role of so and so.
No, but Mr. Ajay, I thought that the rejoinder is one thing, and amending your assessment of fact is another. Joinder is it's a different thing. Yes, they are now joined, but to think out the amendment in the pleadings is also a different thing.
My Lord, when a party is joined and we want to file consequential process, we need to include their name and this description of the party. We can't file without.
Yes. But Mr. Ajay, sometimes you may join a party without tinkering with the pleadings. You can just say that I want so person to be joined without tinkering the main pleadings. But what you do here is that after the joinder, and you now went on to tinker with the fact in the pleadings. There are two different things. You can join or apply to join any person. Once that party is joined, then you can decide not to tinker with your pleadings. And in that case, you can file any consequential process reflecting the name of the persons joined. But you went ahead to amend Yes, Mr. Ajayi.
Oh, my Lord, I'm with you, my Lord.
Yes, Mr. I was trying to all what I'm trying to say is that if I am going to rule on this application, the only process I'm going to use is the initial process filed by the by the claimants.
My Lord,
Which is
the consequential process that we file, the paragraph 2 is a consequential paragraph that flows with the application. Once a party is joined in filing consequential process, we cannot file the consequential process without making reference to the party that was joined, which is the grant 3. In respect of NDIC, the grant 3 of the application for joinder stated the role or the reason why NDIC was joined to the matter.
Okay. What did you say in a new environment, the role played by the NDIC? That will make the court to hold that there is a reasonable cause of action disclosed against.
The paragraph 2.
Okay, where in paragraph 2? Where that's stated in paragraph 2?
It is stated that the second defendant is the body empowered by law to issue and revoke banking license to the banks and or insurance institution in Nigeria, while the third defendant is the body empowered with right to appear in court on behalf of an insured institution, such as the first defendant, whether it bears Mainstream Bank, Sky Bank, or Polaris Bank, and it's empowered by law to render financial assistance to an insured institution, such as the first defendant, whether it bears Main Street, Sky Bank, or Polaris Bank. Empowered to close a failed insured institution, such as Main Street, Sky Bank, Polaris Bank. Empowered to act as liquidator to an insured institution, such as the first defendant, whether acting as Main Street, Sky Bank, Polaris Bank.
May I please, my lord?
Hello, that is the abandonment.
May I please, my lord?
Yes, Mr. Akpan, what do you want to say?
My lord, the statement of the paragraph that my learned friend is reading from seems not to be in the copy that we were served. So I'm struggling to follow him.
That's the... Mr. Akpan, which process were you served with? Were you served with any amended statement of fact?
Yes, there's one here amended. It's dated the... Yes, I have one that is amended and it's dated. That I'm trying to pull up.
Okay, then check paragraph 2.
Dated the 5th day of October.
Okay, check paragraph 2.
Paragraph 2 of the statement of material fact, my lord.
Yes.
Lord, what I have here reads, sometime in August 2021, the management of the first defendant while it was still Main Street Bank. So it's not what my learned friend has read.
Yes, yes.
My lord, it is statement of fact, not statement of material facts.
Yes, statement of fact, not statement of fact. That, maybe that's material fact is attached to the, it's not attached to the.
Oh yeah. Okay, my lord, I'm sorry, my lord, I have seen. Yes, I've seen it now. I've seen it now. I have seen it now. Then, my lord, I also remember that our objection was raised nonetheless, that provision, because this place says that the second defendant, that the third defendant is empowered to appear on behalf of the insured institution. So we had very well reckoned that alleged involvement by statutory powers in the transaction, but then it doesn't talk about employment claims. Okay. And also, my lord.
No, Mr. Akpan, allow me to continue with his argument. Allow Mr. Ajayi to land.
So, my lord,
Mr. Yes.
That is the paragraph that
Okay.
made reference to the third defendant based on the ground for joinder.
Okay, it's okay. So is that all, Mr. Ajayi?
And my lord, to further help the case of the claimant was the purchase and assumption agreement, which clearly stated that they are to take liability.
Okay.
May I please, my lord?
That is our humble submission.
So you wish to report the purchase?
Yes, my lord, purchase and assumption agreement,
Okay.
which is a document before the court.
May I please, my lord?
But just hold on, Mr. Akpan. So, Mr. Jai, that is all, ba?
Yes, my lord, we pray the court to dismiss the application.
Okay. Mr. Akpan.
May I please, my lord? My lord,
Yes.
The issue of the purchase agreement, our response, because it wasn't raised in the claimant's counter affidavit to our admissions of preliminary objection. But Lord, our response is that the NDIC was not a party to that agreement.
No, she was a party. She was a party. Agreement. Mr. Akpan. Yes, Mr. Akpan.
May I please, my lord?
NDIC was a party to that agreement.
Oh, yes. It's NDIC was, yes, that was the point that we made, that assuming that purchase agreement gave liabilities other than as it relates to deposit insurance and protection of the deposit of customers of banks, that the NDIC Act cannot allow the NDIC to respond to claims other than those pertaining to deposit claims. That's the, yes.
Okay. It's okay.
And that, and ultimately at that rate, assuming there are liabilities falling to failed banks outside deposit claims, and especially in this situation where the bank itself is still a going concern, the company is still a going concern, that company has the powers to receive and defend liabilities that may come to it. And that is the decision in this by the Court of Appeal in the Sky Bank case that has been cited by virtually all the parties.
Okay, so we are going to adjourn for ruling after the court's vacation, to a date to be communicated to counsel. Mr. Jai and Akpan. Mr. Jai, Akpan and Mohammed. Mr. Adiba is no more in this matter. Yes. So, Mr. Jai, Mohammed and Akpan, I'm going to adjourn for ruling after vacation. But the date will be communicated to you by the court registrar.
My Lord, will it be a virtual proceeding?
Is that okay? Yes. Mr. Ajayi?
Lord, that's fine, my lord. It's very fine.
I was asking whether it would be a virtual proceeding.
Think so. I think so. It will be virtual. It will be virtual. So cases adjourned for ruling to a date to be communicated to parties after court's annual vacation.
I'm sorry, my lord.
Yes, Mr. Ajayi.
In view of the ruling just delivered by the courts and our application to withdraw against the AMCON. I wouldn't know. I don't know whether it's Mr. Adebayo that is also in the other matters that we have today, so that we can make application that the same.
I am.
Yes,
Okay.
yes, in the other matter.
When we get to the other matter, so we will make the necessary application.
Thank you very much, Mr. Ajayi. That's very
We
considerate.
have three.
Welcome, sir.
We have 347. Aduwari.
Aduwari and 346.
Okay.
347, sir. 346 and 347.
No, it should be 349. The 347 is okay. Aduwari is 347.
347, yes.
Yes, so
347, sir.
are the parties in court, Mr. Ajayi?
Yes, my lord.
Is the claimant in court? Claimant.
Hello, the claimant.
It's in court?
It's not in court. It's not in court.
Okay, Mr. Mohammed.
Yes,
Mr.
my
Mohammed,
lord. Yes, my lord.
is your client represented by?
Sorry, my lord, I want to confirm which of the matters we're calling.
Oh, this is Aduwari.
Aduwari Christopher.
Yes.
Yeah.
No, not at all, my lord. Not at all. So we appear for Polaris Bank.
Yes, Mr. Mohammed.
Yes, my lord.
I said, is your client represented by any staff?
No, not at all, man. Not at all,
Okay.
my lord.
Okay, so what about Mr. Akpan? Is NDIC represented by any staff?
My lord, Mr. Akpan is not involved in the other matters.
Okay, you're not in this matter. Okay,
Yes.
it's okay.
So, my lord, may I then?
Okay, is there any counsel in the
Yes.
in 347?
Yes, my lord. That's me, Olashukwu Adebayo, for the fourth defendant.
No, apart from you are representing
I'm sorry. I'm sorry.
Yes,
Okay.
I'm representing the NDIC. So Mr. Adebayo, is your client represented? Mr. Adebayo. Mr. Adebayo.
My client is represented by the same.
Okay.
For the fourth defendant, sir.
Okay.
For the fourth defendant. My client is represented by Mayok Mwashayi, legal officer.
Okay.
I'm called female.
So Mr. Tio Ajayi for the claimant. Mr. Mohammed Adam for the first defendant. Mr. Adebayo Ola, is it Ola Shufo?
It's Olashukwu Adebayo, sir. Olashukwu is the first name, sir.
Okay.
The first name is Olashukwu. Adebayo is the last name, sir.
Okay, Mr. Ajayi. Mr. Ajayi.
Hello.
So you apply to strike out the
name of the fourth defendant, my lord.
Okay. Yes, Mr. Mohammed, no objection. Mr. Mohammed.
No objection, my lord, no objection.
Mr. Adebayo, no
My lord, I have
objection.
no objection, and I will make no others to cause, sir.
Okay.
I will have no, my lord, I'm sorry. I will not be asking for cause.
Okay. So in view of the application of the council for the claimant to strike out the name of the fourth defendant, NDIC, the fourth defendant's name is hereby struck out
As a court, please.
from the suit.
Very much obliged, sir.
Thank you. Yes, Mr. Ajayi, what do you do? We adjourn for, it's like the NDIC has also filed an application in this suit, huh?
That's what I'm trying to cross-check now. Maybe we take
Yes,
date for the end of the application.
Okay. Joel. Joel. I saw the face of my registrar, but it's now off. Hello, Joel. Hello, Joel. We are on 347 now. Can you give us a date for hearing of pending application?
Okay, sir.
After vacation.
After vacation, I don't.
Hmm?
Wow.
Yes, I can hear you. Is that Haja? Yes, I can hear you. The other matter was adjourned to a date to be communicated to council for ruling. And we are on 347 now. Yes. Polaris Bank, yes. Fourth defendant name has been struck out. Then I think that the pending application filed by the third defendant, NDIC. So we now want a date for hearing of the pending application. 21st. Yes, for hearing of pending application. No. In the other matter, 348, Babatunde.
348,
We are done with that one. It was that for renewal will be communicated to council.
Okay.
After vacation.
Okay.
Then we are now on Aduwari, yes. Aduwari. Fourth defendant's name, Amcon, has been struck out.
Okay, that's 349.
No, it's 347.
347.
We have two remaining defendants now, Polaris Bank and NDIC.
Okay.
And I think there is an application filed by the NDIC.
Okay.
But the counsel for the NDIC is not in court.
Okay, sir.
So we need a date for hearing of the application filed by the NDIC after vacation.
26th October, my lord.
Huh?
October 26th.
Okay, 26th of October.
Yes, my lord.
My lord, sorry, it's not convenient for me. I have a trial in Ikeja on that day, and I have to be physically present.
Okay, it's not convenient to
Convenient for
Mr. Clement Council Aja.
Should we go to December?
Why should you go to December now? Oh, Ajayi, should you go? Ajayi?
My lord, if you can have an earlier date, I wouldn't mind, sir.
React whatever they want to react.
No, he has already reacted. Parties have already joined issues.
Okay, my lord, I will take it. My lord, I will take it. I will take it. My lord, I will take the 26th. You have just confirmed with my colleague who will assist me to do the other matter.
He's saying that the 26th of October is okay for him.
It's not convenient for him, sir.
Yes, it is.
Oh, okay.
Mr. Mohammed, Adam.
Yes, my lord.
Is that okay? 26th of October.
Yes, it's fine, my lord. 26 is fine.
247. 2019.
Yes, 247 2019. Aduwari. Yes.
26th October.
Okay. So case is adjourned to the 26th of October 2022 for hearing of pending application. Thank you. Then the next one is 349.
Okay.
349. Fourth defendant is represented by
Olashukwu Adebayo, sir.
yes.
Mayokun Ashaye.
Ashaye.
Council Mayokun Ashaye.
Oluwa Mayokun.
Mayokun.
Ashaye. Other parties absent. Mr. T.O. Ajayi for the claimant. Muhammad Adam for the first defendant. Yes, Mohammed, for the first defendant. And any
Yes.
counsel for, yes, any counsel for the third? Mr. Ola Shupo
Idigbe,
for the
fourth defendant.
fourth defendant. Mr. Ajayi,
For the claimants.
yes, the matter is for hearing of pending, but we wish to apply to strike out.
The name of the
Yes, sir.
Okay. What defendant? Mr. Mohammed, no objection. Mr. Adebayo,
No objection, sir.
no objection.
Apologies, my lord. My network was failing.
Okay, is that Mohammed?
Yes, my lord. Yes, my lord.
Okay. Wow. So in view of the application of the learned counsel for the claimant to strike out the name of the fourth defendant, the fourth defendant's name, Amcon, is hereby struck out from this suit.
As the court pleases, sir.
So we should adjourn to the same 26? Same 26, is that okay?
Yes, my lord.
Okay, it's okay?
Yes, it is. It is okay. It's okay, my lord.
Thank you.
Yes. My lord, if I may just make a very short comment.
Is that Mr. Mohammed, yes?
Yes, my lord. I said hopefully before that day, we would have also filed our application, because a look at our statement of defense to the claimant's suit against us, we have made a point of law known, which we are hoping that the court will probably.
Mr. Babe, why would you leave that till the final address?
As the court pleases, as the court pleases.
Yes.
As the court pleases.
You can still file, but we'll keep it in abeyance till the final address.
As the court pleases.
So matters adjourned to 26th of October 2022 for hearing of pending application.
As the court pleases.
Thank you. So we're now done with the three Polaris Bank cases.
Yes, sir.
Mr. Adebayo, I want to decide and acquit you.
Thank you so much, my lord. I'm most grateful, sir. Thank you.
Thank you.
And I wish my lord a very fruitful and rewarding vacation, sir. Very restful one, sir.
Thank you.
Yes, sir.
Mr. Ajayi and Mohammed.
Yes, my lord.
Thank you so much. That will be all for Polaris Bank cases, ba?
Yes, my lord. We are very grateful for my lord. And if I must say, this is my first virtual hearing. And in fact, I can imagine how it will be for all litigators if this can be fully adopted for all proceedings.
Yes. It saves us a lot of things.
Yeah, yes, my lord. Yes.
Time, energy, and resources.
Very well, my lord. I imagine what I would have faced if I had entered traffic today. I wish my lord a very wonderful vacation.
From my house to the court, sometimes I will spend 3 hours, 3.5.
Wow.
During that fuel crisis, sometimes in March, I spent 5 to 6 hours before I got to the office.
Wow. That's
5 to 6 hours. Yes, I was living at Sangotedo.
Whoa.
That's my access to my lord. I hope to move out of the place very soon.
That place is so terrible.
It's worse now, my lord, that the construction is even ongoing. It's worse.
Yes, construction is there. There is this Aja flyover.
Yes.
And so many things.
All right.
We are thankful to technology. We can do our things virtual.
All right, my lord. We are grateful to the court.
Thank you. Saki.
Bye. Thanks, everybody. See you all later.
All right, sir. Mr. Adebayo, we will not see you again. No?
Well, we'll see. We are practitioners of talk.
All right, sir.
All right, bye-bye.
Mr. Adebayo can go and enjoy himself.
Okay, we still have this case 31150/2021. Is there any?
Yes, my lord. Yes, my lord. Yes, my lord.
Okay, and the matter?
Yes, my lord.
So, Malam, may we be excused, sir?
It's okay, Mr. Adebayo. Thank you. Mr. Jai, thank you.
Oh, thank you very much, sir. All right, sir.
You're welcome.
Very good.
Okay, Mr. Jai, thank you. Yes, Mr. Nuruddin.
Yes, my lord. We are interested in the case of Chartered Insurance Institute of Nigeria.
Yes.
Mr. Emmanuel Emenue, sir.
Yes.
In order to adjourn it till today for further adoption of the processes before the court. But
Yes.
we are surprised when we received the link for today's proceedings that was slated for ruling. But
No.
okay, sir.
It was a mistake from the
Oh, very
registry.
well, my lord. Very well. We thought as much, sir. We thought as
Yes.
much.
Yes. So, are the parties in court or their
No, parties are absent. But my
okay,
lord, yes, my lord. There is one. A participant was on the call before now. I wouldn't know whether it's the defendant's counsel, but now it appears the person has left.
no,
I
no,
wouldn't know.
there's still somebody, George, and
But, no, George is my colleague. George is my
okay,
colleague.
My lord, I'm appearing with my senior
okay,
colleague.
Yes, we are on the same side, my lord. We are for the claimant, but I wouldn't know whether the participant has left. But we received
okay.
the link for today's proceeding, and that is why we are here, my lord. Subject to my lord's convenience, may we announce our appearance, my lord.
But the thing is that it's like we were at the point when Mr. Achoy counsel for the defendant was opposing the application.
Yes,
We
my
said
lord.
in opposition to we file an paragraph of counter affidavit dated so and so. We've also filed a written address to accompany the.
Yes, my lord. We have the counter affidavit of the respondent. We filed the counter affidavit of the application, then we filed the further affidavit. Then
When?
we filed a further
When did you
counter.
file the further affidavit?
Yes, my lord. We actually filed the further affidavit, and
When?
our further affidavit is filed on 26th of January 2022.
Okay, that was before the application was
Yes,
was
before the
taken.
last proceeding. Yes, before the last proceeding.
Okay.
And surprisingly, my lord, they also filed a further counter affidavit. That's the defendants now, the defendants counsel. They filed a
When?
further counter affidavit to our own further affidavit.
Okay, the further counter before
the last proceeding as well.
Okay.
Then we also filed further and better affidavits to their further counter affidavit, sir.
Okay.
All this were actually filed before the last proceeding. And yes, I understand that.
Yes.
Yes, I understand that all the processes were referred to at the last proceeding.
Yes.
So there are no new processes.
This is what Mr. Khalid said.
Yes,
Our
my lord.
application
Yes.
is dated 24th June 2021. We're filing on the 25th of June 2021. The
Exactly,
two remaining prayers are contained on the face of the motion paper.
Yes, my lord.
It's supported by an affidavit of 10 paragraphs.
Very well.
8 exhibits are attached. We've also filed a written address. Upon being served with counter affidavit, we've filed a further affidavit with 1 exhibit and a reply on points of law dated 26 January 2022. We've also filed a further and better affidavit to the respondents, further counter affidavit on the 5th of May 2022. We adopt all our processes and urge the court to grant our application. Then Mr. Achoy say in opposition to the application, we have filed an 8-paragraph counter affidavit. 8-paragraph counter affidavit dated 17th January 2022 and attached exhibits A to G. We have also filed a written address to accompany the said counter affidavit. We have also filed a further counter affidavit on the 6th of April 2022 and attached exhibits. We adopt our written address as our argument and submission. Then at that point, the Mr. Achoy said we apply for a date for continuation of argument. Then cases are adjourned to the 21st of July 2022 for continuation of hearing of the claimant's motion on notice. So, Mr. Nuruddin, what do you do? Should we still go ahead without the
Yes, my lord. Yes, my lord. We believe we can proceed with the adoption of the processes. In any event, the defendant's counsel too at the last proceeding was present in court and he was aware of today's proceeding. As a matter of fact, he actually previously joined. I don't know why he left. I don't know why he
Okay.
left. He left with
No, it might have been a network issue, but let me call the. Let me
Sorry, my
call
lord.
the. I say it might have been a network issue, network problem.
Very well, my lord. Very well, sir.
But let me call the registrar.
As a copy, very well.
Dear customer, the MTN number you have dialed is not reachable at the moment.
Yes, Aja. We are now on 150 stroke 2021 Chartered Insurance Institute of Nigeria. And Mr. Emmanuel, the counsel for the claimant are here, but we have not heard about the counsel representing the defendant. Yes, he hasn't, because we haven't seen any. Call him so that we. I can see. Yes, you can call him. Actually. Okay. So we're waiting for you, Aja. So Mr. Nuruddin. The registrar is going to call the.
We are grateful, my lord. We are grateful, sir. We are grateful for the indulgence.
Okay. Mr. Nuruddin.
Yes, my lord.
Did he call you?
No, sir. No, we did not receive any
Okay.
calls from.
What the registrar said, he told her was that he had earlier on joined.
Yes, my lord.
Yes, but got disconnected, because
Okay.
of the network issue. Then he's now trying to reconnect.
He's discussing it, sir.
Yes,
He
he's
appears
trying
to be
to.
discussing with my colleague. Yes, he's discussing with my colleague. WhatsApp. So I think he's saying that he had difficulty in joining again after
Yes.
he got disconnected.
Yes, so he's now trying to log in again.
Well, Melon, may I just suggest that? May I
Yes.
suggest, because
Yes.
nothing really, because the record is there to bear us out. Nothing is being done behind him to his detriment. We are not taking anything since all the processes have been adopted. We are not adding anything. We are not filing any further thing.
It's like he was I think he wanted to add on bread.
Oh, very well, very well, very well, very well.
Yeah. Hello.
Come.
We are
Hello?
glad.
May my Lord be pleased.
You're welcome.
My sincere apologies to the Honorable Court.
It's okay.
I was in the first proceeding. All of a sudden, I got logged off and been trying to re-enter.
Yes, that's what I just said.
Yes, my Lord. I sincerely apologize. I might have to speak off camera. I intended to be in Lagos as of this date, but unfortunately I couldn't. So I'm not properly ruled.
It's okay.
Yes, my Lord.
It's okay. So let me take your appearance, Mr. Nuruddin.
Yes, my lord. May the court be pleased. Nuruddin Emmanuel, my lord, I appear for the claimant with George Anyo Jongbe. We both appear for the claimant.
With George Anyo
Jongbe.
Yes, for the claimant.
Very well, my lord.
Yes, Mr. Atewe.
Yes, my Lord. Yes. Chukuyem Atewe, my Lord, for the defendant.
Yes.
Yes, my Lord, for the defendant. Yes, my Lord.
Yes. The matter is for continuation of.
It is continuation of the Maraba injunction. Well, I know the last date, my Lord, have adjourned the application for ruling, but my Lord hinted and the event that the ruling is not available as of date, that parties may have to readopt their arguments for further hearings.
No, just to continue with the argument. You stop at the point of. Are you referring to this case?
Yes, my Lord, my Lord.
No,
for us as defendants, we'll
adopt. What you said after the claim council moved this application, then you started doing your own. You said in opposition to the application, you will file an 8-paragraph counter affidavit dated 17th of January 2022, and attached exhibits. We've also filed a written address to accompany the said counter affidavit. We filed a further counter affidavit on 6th of April 2022 and attached exhibits. We adopt our written address as our argument and submission. We apply for this for continuation of. So is there any, the matter is for continuation of hearing of the application of the claimant's application?
Yes, my lord. The only thing I needed to add to my argument.
Yes.
The deed of conveyance being relied on by the claimant to say that the property belongs to the defendants.
The defendant,
is not registered. Yes, it's not registered, but the firm belief and confidence on that particular document.
Oh, it's not registered?
Yes, my lord, it's not registered, but that is what the claimant are hinging on, that the property belongs to the defendants. So the defendants have also presented before the court a deed of conveyance. Yes, my lord, a deed of conveyance or assignment to show that the property has been sold by the defendants and the wife. Now,
that deed of conveyance, was it registered?
Was also not registered. So the claimant cannot be probating and be reprobating at the same time. They relied on a registered deed of assignment to show that the property belongs to the defendant, and also oppose a deed of assignment that is not registered to say that the property has not been sold. So they cannot be speaking from both sides of the mouth. My position, my lord, that the documents are the same pedestrian. So if they are relying on a registered deed of assignment to show that the land belongs to the defendant, then they cannot also be opposing a deed of conveyance that to show that the document that the defendant is saying that the property has been sold, to say that the property have not been sold on the basis that it's not registered. Meanwhile, they are relying on a deed belonging to the claimant, the defendant, that is not also registered. So we are on the same pedestal on the issue, but we strongly submit, my lord, with the greatest respect, that the said land has been sold. It has been sold by the defendant. So that is our position, my lord, and we humbly submit, with the greatest respect, that the motion brought by the claimant should be struck out.
The document sought to be relied upon by the claimant is what? What's the name of that document? Is it deed of what?
Yes, it's deed of conveyance between a vendor to the defendants and the wife, as reflected on the face of the document, sir.
Is that a document that the claimant wants to rely on?
Yes, that is the document they are relying on to say that the land, the property belongs to the claimant, to the defendant, sir, to the defendant. And that particular deed of assignment of conveyance, as it were, it was not registered, but it's the same deed that the claimants have confidence to say that the property belongs to the defendant. And the defendant have, in the same vein, also tendered a deed of conveyance to show that the property, and to show that the property, that he has sold the property in conjunction with the wife to a third party.
What did that
to say no, that deed was not registered.
But that document executed?
So
the document was assisted sometime in August or so. I have to be careful in making submission as reference to the documents before the court, as I'm not with my file. So, but the documents are as attached to the processes filed by the defendant respondents in opposition to the applications.
May I respond to the contention by my learned friend?
Yeah, let him finally land.
I think he has landed.
Okay, Mr. Atwe.
Yes, my lord, it's on the totality of the on the counter affidavit and subsequent further affidavit filed, further counter affidavit filed, and the written addresses therein that we relied on the same.
Okay.
In urging my Lord to dismiss this very application with substantial cost.
Okay, Mr. Nureni, what do you want to say?
Yeah, thank you, my lord. Thank you, my lord. I'm only going to address the sole issue raised by the learned counsel to the defendant, and that is as to the registration of the title document that the learned counsel talked about. My lord, we have filed all the processes and all the papers are before the court, and I believe that my lord is seized with all the facts. But on the registration of the title of the document that defendant's counsel is talking about, what is clearly in issue is what needs to be proved. What is admitted and what is clear between the parties is that the subject property that we are talking about belonged from the beginning, belonged to the defendant. There is no dispute as to that, as to ownership, as to the primary ownership of that document. I'm coming, my lord. I just want to analyze what my legal friend
has changed hands.
Yes, my lord. Primarily, from the beginning, we both admitted, we both agreed. They also admitted that the property in question primarily belonged to the defendant. There's no controversy as to that. Secondly, regarding what my learned friend is talking about, registration of the document, it is not our own duty to register that document. The document belongs to you. You need to register it. Whether you registered it or not, you have title of the document. So title is not an issue. We are not fighting over land here. We are not fighting over who owns what. We are not fighting over property. We only brought in this property to restrain the defendant, and the defendant actually admitted that the property belonged to him. So what is an issue is whether the property had been disposed of, whether it had been sold, whether it had been validly sold. And our own contention is simple here. And I'm thankful to my learned friend. He has also admitted that their own document too is not registered. They said they transferred it to a third party. If at all, the argument is counterproductive to the position of the defendant, because you said you transferred it to another party and you have not registered it too. So it's not our own duty to prove. I'm coming. I'm coming. It's not our own duty to prove that you did not register your title. It's for you. But our position is that, yes, my lord. Yes, my lord.
Supposing the defendant is only trying to say that there was a sale of the property to a third party, not trying to say that to prove title.
Very
just to say that, just to prove sale.
I agree for that, because what is clearly in point here is whether the property had been validly sold. We knew who owned the property. They admitted that the property belonged to the defendant. But what is an issue here is whether it had been sold. And our contention is that it cannot even validly sold. First, because as he rightly admitted, their own title of conveying it to the third party was not even registered one. Secondly, it cannot be sold while there is a caveat on it, because we have.
But when was this sold?
Yes,
my lord, it was sold in August.
It was sold in August.
Yes.
They said it was sold in August 2021.
Yes.
Meanwhile, the suit had been filed as far back
before the interim order was granted, isn't it?
Very well.
Yes, it was before the interim order was granted, my lord.
Yes.
My lord, if we go to the checker history of this matter, we have already mentioned to my lord that while the matter was pending, that parties had met severally and attempted to resolve this matter. A commitment was made. It was when the claimant reneged on this commitment that they now kick-started the processes further in court. And as of the time commitment was being made, we exchanged correspondence, which is also before my lord, that the claimant, the defendant, was borrowing money and using this property as a collateral for the purpose of that loan. And even among the processes before the court or the document attached, we also show that there was a demand for the refund of the money from the claimant when they reneged on the commitment made. And the defendant has also stated in the document that it was when he borrowed the money, the property as collateral, it was when the people he borrowed the money from were not demanding for their money and he could no longer meet up, that he also informed the claimant that he have sold this property. All of that is before the court. But as he stated, The essence of the document before the court is to show that there was a sale transaction, and it is actually the buyer, the purchaser of that property, that has the duty to register it, not the dependent as it were, as the point that is being made now. It's not the dependent. It is the person who the property has been sold to that had that duty. But as of when this action was filed, what we have before the court is the evidence of the deed of conveyance as transaction of that land, that the land has been transacted on, and it's not to a third party. So all of this is not an issue. So that is a correct position, my lord. I will speak from the bar that this truly that there was a transaction on that land, and the property has been sold to a third party by the dependent and the wife. The wife also, which is not a party before this court in this matter, sir.
But
also, we strongly submit, my lord, that
unfortunately, I was not allowed to land before my learned friend interrupted.
Mr. Nureni, I want to ask this question.
Very well, my lord.
Supposing your application for interlocutory injunction or interim, Mareva is granted.
Yes, my lord.
Pending the termination of the, main substantive suit.
Yes, my lord.
And supposing judgment is given, in your favor. Judgment is given in favor of the claimant in this. What had that property got to do with the substantive matter?
Very well, my lord. Because yes, my lord, the challenge, the helpless situation we find ourselves, and why we believe that the property can the only lifeline we have in respect of this matter is that property, because immediately the claimant, the defendant got to know that we have filed this, we have still this matter. He withdrew all his money. As a matter of fact, well, the matter, I don't want us to prejudge the matter. We are still going into the full plenary regarding the matter.
You can't prejudge the matter, but you are preempting the court to give
No, we are not preempting. We have an application. Calm down.
Mr. Nureni.
My lord asked me to address.
What I want to ask, Mr. Nureni, what I want to ask is that, supposing the claimant's application for Mareva injunction is granted,
yes,
and supposing judgment is given in favor of the claimant in the substantive matter.
Yes, my lord.
Then what has that property got to do with the substantive matter?
That's what I'm explaining before I was interrupted by the learned.
No. Okay.
Don't you think that,
Mr. Nureni, don't you think that at the end of the day, even if this application is sustained pending the determination of a substantive matter, since you don't have any relief, do you have any relief in the substantive matter against that property?
Of course, my lord, of course. Yes, my lord. We have a relief of about 400 million, over 400 million.
No. Not against that property.
Against the property?
Yes.
Yes, my lord. We have other reliefs. We have other reliefs apart from the property itself.
No. My simple question is, in your substantive release,
yes,
the release containing assessment of fact,
yes,
do you have any relief against that property?
Okay, in connection with the property,
as we have had it in your motion on notice, as you have had it in your motion for yes.
Yes, my lord, we do.
Okay.
We do, yes. May I read it out, my lord?
I read it.
Very well. We seek relief for an order of this honorable court. Yes, relief E, an order of this honorable court attaching the defendant's property at Lamina Soja Street, Igbo Oluwa Estate, Ikorodu, Lagos State, in partial satisfaction of the judgment sum.
Okay.
The relief is, yes, it's substantive, my lord. It's substantive because, as a matter of fact, the defendant is not present in the country. He has moved his family. He has moved all the money. He has nothing again. The only thing we can hold on to continue without the frustration of this matter is that property in question. Which is why the defendant is playing all pranks to just to make sure that the property is off the hook. So we ask for substantive relief against the property in itself for attachment of that property in partial satisfaction of the entire relief we are asking before the court. He has swindled the claimant of over 400 million naira in this matter.
It's okay. It's okay. It's okay.
Yes, my lord. And we have all the processes before the court. So, like I was explaining, my lord, before now. Yes, like I was explaining before the defendant interrupted me, I was saying that first, the title is not an issue here. The defendant agreed that the property primarily belonged to the claimant, to the defendant. And we also believe that it belongs to the defendant. So at some point, they said they sold it. We are saying that it cannot be validly sold while it's a subject of litigation in the suit. It's a subject of lawsuit. It's a subject of, so they sold it in bad faith. Meanwhile, even before the sale, we have filed a caveat.
How was it a subject of litigation?
We are seeking a relief against it in a substantive suit. They are aware of that. We actually filed a motion for injunction, and we served them with the motion for an injunction while the suit was assisting. And they went ahead, and according to what he said, they sold it during the pendency of the suit. That is one. Secondly, my lord, we filed a caveat as a constructive notice to the general members of the public that they went ahead in sale of that property in defiance to the sanctity of the court. So, my lord, our relief here is simple, and our application is straightforward.
When did you file?
Yes, the application is simple, and it's for attachment.
The caveat. When did you file the caveat?
Yes, my lord. We filed it in April, and they said they sold it in August. We filed it in April, sir. It's the main exhibit to our further affidavit. It's the main exhibit to our further affidavit, sir. So we filed it in April. Yes, my lord. So the application is straightforward.
Okay, Mr. Nuruddin.
Yes, my lord.
The issue of filing a caveat is mentioned in a further.
Very well, my lord. In our further affidavit, yes, my lord. Okay. And that's the only exhibit that we attached. As a matter of fact, sir, the caveat was advertised not just in one national newspaper. It's about 3 national newspapers, and it was well advertised, my lord. So the sale, we believe, if even if valid, was in bad faith, and it was in disregard for the sanctity of this honorable court. At the end of the day, they wanted to render nullity, purgatory, whatever relief we are going to get from this court. And we believe that this honorable court has the power to protect its own sanctity and uphold its own and protect the rest. So that at the end of the day, whatever victory we are getting from the court will not be in vain. So, my lord, our application is straightforward and it's so simple. Our application is that let this subject property be restrained. Let no party touch it during the pendency of the suit. We are not saying that they are liable or whatever. It's for your lordship to decide that at the end of the plenary. But they should participate in these proceedings. At the end of the day, your lordship will know the proper order to make. So our application is simple. We want your lordship to restrain it pending the determination of the substantive suit.
Okay.
Yes, my lord.
It's okay. I'm going to adjourn for that's after vacation for ruling.
As the court pleases.
As the court pleases.
John, my lord, we have already also made the point that the property belongs to 2 parties, the defendant and the wife. And the wife is not a party before this court, my lord. So
all this is before my lord. I will not allow.
Yeah, I will not allow. Please, let's allow me to land. I am on the point of
all
law.
This is before my lord. There will be no end. As a matter of fact, the learned counsel for the defendant is in the habit of filing processes after process.
Yes, I'm not recording.
As the court pleases. As the court, let my lord decide. We have all the processes before the court.
It's okay, please, Mr.
I think the parties, with the greatest respect to my learned friend for the claimants, parties are allowed to fight their processes as valid and competent before the court. So it's to the court to determine which of the processes. It's not a matter of part of habit of filing processes. It's all of them are before the court, and you have also reacted accordingly. But the point I'm trying to make to my lord is that 1, the property is jointly owned by the husband and the wife, the defendant and the wife is not a party to this suit. and the wife have not granted anything as of right to the defendant, as a matter of this property being a subject of litigation. And we have also made the point to my lord that parties entered into discussion with a view to settle this matter, and commitment was made. And at that point, it was made clear to the claimant that this property was a collateral, and thereafter that the property has been sold. My lord cannot make an order of court in vain. So if there's already a third-party caveat on the property that has been sold, so
but he's saying that
my lord is not going to be asking.
But Mr. Achewe, Mr. Achewe, can you hear me?
My lord, by the
no, can you hear me, Mr. Achewe?
And also contained in our exhibit before the court is
Mr.
that we have
Achewe.
exchanged correspondence.
Mr. Achewe.
Yes, my lord. Yes, my
lord. What he's saying is that there has been a caveat on the property since April this year. He has indicated that in his counter affidavit. He has also, referred to the document about the caveat.
Yes.
But you still went ahead. To sell that property, regardless of the.
No, that will not be entirely correct, my lord. That will not be entirely correct, in the sense that even as of that April, when they said there was a caveat, my lord will also see that we also attached a document, a letter from my office as an associate of the defendant counsel, saying that there cannot be a caveat since one of the parties is not a party to this.
Okay, but Mr. Achewe, when we are trying to, when you are trying to settle the matter with the claimant out of court, was that property, among the things that you wanted to surrender to?
Yes, my lord. My lord will see in our correct.
Yeah, that property was one of the things that we wanted to surrender to the claimant as part of the settlement, isn't it?
No, that property was a collateral to borrow money to settle the claimant. It was when the claimant now.
Okay. Collateral
and now came back
to who? Mr. Achewe?
Was a collateral. Yes, the defendant borrowed money from friends. Friends and family.
He used the property. Lord. He used the property as a collateral to borrow money.
As a collateral, yes. And yes, my lord.
Okay, a property that's jointly owned by him and his wife.
Yes. As of that time, he had that discussion with the that let this property stand as a collateral to raise money. And all of this, the point I'm trying to make, my lord, is that the claimants were all along being carried along, even up to the point that the property was sold. And it was after making that payment, a payment of 40 million to the claimant, that the claimant informed the claimant, my lord, that this property is no longer available.
Mr. Achewe.
With respect.
That deed of conveyance that you have exhibited, Mr. Achewe.
Yes, my lord.
That deed of conveyance that you have exhibited is between who and who?
Yeah, the deed of conveyance is between the claimant, the wife, and to a third party, my lord. Already, between the defendants, the wife, and a third party, sir. I humbly apologize. I'm not present.
Is the wife one of the
and I was hoping
parties to that deed of conveyance?
Yes, my lord.
Are you sure?
Yes, my lord.
Okay, it's okay. I'm going to look at all the processes.
So, Lord, may I correct an impression here, sir?
Yes, what's the impression?
Yeah, thank you, my lord. First, let counsel for the defendant just mentioned now that the property was used as a collateral and it's part of the discussion during negotiation. That is untrue. They never mentioned anything regarding the property during negotiation. It was after we filed that they filed and they started exhibiting some documents saying that or purporting to show that they actually transferred the property. Also, he mentioned that they used the property as collateral to raise money. The way we understand this, sir, if property is used as collateral to raise money, it is the other party that you borrowed money from that will sell the property. They sold, according to them, they themselves sold, the defendants themselves sold the property. And in any event, if the wife has interest in this matter, or even if the purported buyer has any interest in this matter, they can apply to join. Let them come and join. They can participate in the proceeding. All we are saying is let the property stay as it is now. At the time
when the property is no longer live before the court, the property is no longer live before the court.
Let me land now. I didn't interrupt you, my lord. I see the protection of the court. I see the protection of the court. I'm still talking, and the defendant is in the habit of this. So, my lord, what I'm saying is this: if a third party has bought it, let the third party join. Let him participate in the proceeding. If the wife has interest in the property, let her join. The court is for everybody. If anybody has interest to be protected in any pending litigation, the rule of the court allows anybody to join. As a matter of fact, the defendant himself can apply that anybody should be made a party to the suit. But it's their own choice. My lord, what is clear here is that the defendant is shying away from the true status of that property. If the property was used to raise money, as he has said now, and as in any event, it's an extraneous fact. All the proofs are before the court. If it was used as a collateral, what from whom? You didn't mention the bank. You didn't mention the lending party. You didn't exhibit all the documents that you used in using the property allegedly as a collateral. You didn't exhibit any of that before the court. It's extraneous. It's inadmissible. So when we come to the plenary, anybody that has interest in the suit, let them fight their processes. Let them join. Let them participate. It's for them. But our own contention here is let the property be restrained, because we know that the property cannot be validly sold while the suit is pending before the court.
It's okay. So I'm going to adjourn it after vacation for ruling.
Yes, as the court pleases.
That is going to be communicated to you by the registrar.
As the court pleases.
So cases adjourned for ruling to a date to be communicated to council after court's annual vacation.
As the court pleases.
So Mr. Nuruddin, George, and Mr. Atoe, that will be all for today.
Yes, my lord.
I wish you a very good afternoon.
Thank you, my lord.
That's godly. Most grateful, my lord.
So thank you so much. That will be all for today. Thanks a lot. Bye-bye.
Thank you, my lord. We wish your lordship.
Okay. We thank my lord. Thank my lord. We wish my lord the fruitful vacation, sir, and rest from the loyal sect.
Thank you.
Thank you, counsel, for the claimants. Yeah?
Thank you, sir.
Okay. Bye-bye.
Yeah.